So here's something interesting. The fundamental question that we need to wrestle with in South Africa right now is whether our legal system has created a framework that inadvertently rewards illegal occupation while punishing lawful property ownership. What's core to unpack here is that we're dealing with two constitutional rights that constantly clash. The right to property ownership under Section 25 of our Constitution and the right to adequate housing under Section 26. This tension has created a situation where property owners are spending tens of thousands of rands and waiting for years just to reclaim what is legally theirs. The numbers tell us an interesting but scary story when we look closer. According to the TPN Squat Index, squatting rates have risen from 3.4% to 3.7% since the end of 2023. That might seem like a small increase, but when you consider that South Africa has over 3.6 million people living in informal settlements, with that number growing by 8% between 2017 and 2024, you start to see the bigger picture. We're talking about 3,200 informal settlements recorded nationally and a housing backlog of approximately 2.3 million homes, according to Stats SA and the Human Sciences Research Council. For a clearer picture of all of this, we need to understand the Prevention of Illegal Eviction from Unlawful Occupation of Land Act, commonly known as the PI Act. Schindler's attorneys Chantal Gladwin Wood and Anya van Wyk explained that this law essentially means that no one can be forcibly removed from a property without a court order. Okay, sharp. It's useful to understand that this applies whether someone invaded vacant land, overstayed their lease, or simply stopped paying rent and wouldn't leave. The thing here is, the PI Act doesn't grant ownership rights to squatters. It just makes the eviction process incredibly complex, like in Johannesburg CBD. Property owners must follow 6 strict steps: issue a notice to vacate, approach the court if occupiers don't leave, serve the notice of motion through the sheriff, attend a court hearing where factors like vulnerability of occupiers, all of those things are considered, wait for the eviction order to see if it's granted, and then finally have the sheriff execute the eviction. Steve Wood, writing on tenant evictions, he notes that the Protection of Eviction Act 1977 extended even to commercial properties, meaning you cannot use force to enter a property where someone is residing, whether that's against the person or the building itself. The best angle to see all of this is through the actual court cases. Take, for instance, City of Johannesburg versus Blue Moonlight Properties from 2011. The Constitutional Court emphasized that municipalities must provide emergency housing to evicted squatters, or consider Barron and others v. Claytile in 2017, which confirmed that while private owner rights must be respected, evictions cannot result in homelessness without reasonable alternative accommodation being arranged. Okay, fair or unfair? I don't know. But do you think that all of these requirements for alternative accommodation for things like illegal eviction should be put in with the protection of people from homelessness? I don't know. Let us know down below and let's have this conversation out in the open. With all of this, I want you to understand that there's a massive financial burden that's placed on property owners. According to legal experts, an unopposed eviction typically costs between 15,000 Rand and 25,000 Rand. But here's where it gets truly problematic. If the eviction is contested, all of these costs, they can skyrocket to between 40 to 100,000 Rand or even more. These figures primarily cover things like lawyers' fees, which range from 1,000 Rand to 3,500 Rand per hour, plus sheriff costs that can run from 1,000 Rand to 10,000 Rand depending on the property size and the number of occupants. In another case, the landlord mentioned that they were owed 81,000 Rand in unpaid rent plus 57,000 Rand in water and electricity, and they spent 40,000 Rand on legal fees, and they still hadn't received even a court date. When we take a macro view of this situation, approximately 7,500 eviction applications were filed in South African courts in 2023, according to Legal Aid South Africa. Around 65% of these applications relate to unlawful occupation of privately owned land, yet only 58% resulted in successful eviction orders, with there being delays that occur in nearly 30% of all the cases due to humanitarian considerations and municipal intervention requirements. Look, this whole situation is It's not great, but I want to know, have you ever known or dealt with a squatting issue? A family member dealt with it. What was your experience? What was the process like? And how did it end for you, if it even ended? Let us know down below. Now, another thing that I have noticed is how the presence of vulnerable occupants completely changes the dynamics of things like evictions. In cases involving children, the elderly, or disabled persons, courts postpone eviction orders in over 40% of those instances, pending municipal provision of alternative accommodation. The law gives special consideration to what it calls vulnerable tenants, women-headed households with children, the elderly, and the disabled. But how I want you to see this is through a real-world lens. Near Lonehill, residents dealt with squatting tenants who were dangerous drug addicts for over 3 years. The landlord, showing remarkable sympathy, offered things like cash incentives amounting to tens of thousands of rands for them to leave, and they simply refused. Now, after the eviction, they squatted on the roadside, erecting a shack on another citizen's edge. It took weeks more for law enforcement to demolish the shack and evict them again. When the landlord finally regained their property, everything had been stolen. Wiring, metal, geysers, sinks, toilets, you name it. All of it was gone. What was their recourse? Well, nothing. Law enforcement refused to act, and the civil action was pointless as there was nothing to recover. The question that has to be asked is, should landlords be responsible for the welfare of illegal occupants who have never paid rent? What's your take on all of this? Because I think that our law is too laissez-faire. It just allows for anything. The bigger picture is also interesting when you understand that despite legal requirements, only about 60% of municipalities actually have formal emergency housing plans in place as required by the PI Act. Municipalities in Gauteng, Western Cape, KwaZulu-Natal, they account for over 75% of the alternative accommodation provided to evictees, meaning that other provinces are severely lacking. Take that Lonehill situation as a case study. The Clay Oven and Ginger Park informal settlements, they've become a focal point of community frustration. Deputy Headmaster at St. Peter's School, Vijay Maharaj, once pointed out that authorities, they were being reactive instead of being proactive with regards to the situation. Malcolm Lawson of the Lonehill Residents Association highlighted that Ginger Park has multiple eviction orders, some dating back several years, yet no meaningful enforcement has ever taken place. Well then, what is the point of legal processes if they're going to be ignored? That's what they were asking. MEC for Agricultural and Rural Development, Vuyiswa Ramakgopa, at the time acknowledged that these frustrations, but she also said that they couldn't commit to specific deadlines. Former Mayor of Tshwane, Solly Msimang, explained that when illegal foreigners are involved, human rights lawyers jump in saying you cannot remove them without providing alternatives. Illegal immigrants. While the government says it cannot provide housing to non-citizens, which creates a legal deadlock. Can you see it now? Can you see how this just doesn't make sense? It needs logic. Logic that sometimes isn't available in legal frameworks and documents. But I don't know. Let me know down below. The thing here is that not every eviction story ends in frustration. Action SA's recent 2025 announcement about the successful removal of 300 illegal squatters from Wolwespruit wetland near Solomon Mahlangu Drive actually shows that it's possible where there's sustained political will to get this thing over the line. What is quite interesting to note in this particular one is that this settlement had existed for nearly 20 years. We're not talking about a recent land invasion, but an entrenched community that had grown roots illegally so. But how I want you to see this is through the lens of persistence and proper process following. The city of Tshwane's journey started with eviction notes in November of 2021, recording 192 households, 110 South African, 67 Basotho, and 15 Zimbabwean. When their July 2022 court application to relocate occupiers to Orchards Extension 10 failed because the squatters refused to move, they didn't give up. The municipality carried on. Even when their urgent eviction application was dismissed with costs due to lack of urgency, they regrouped and placed a new eviction application on the normal court roll almost immediately. Political will. The numbers tell us an interesting story when you look closely. Out of those 192 households, only 70 South Africans were verified for relocation assistance, and most have now been moved to Municipal. The city identified permanent stands above the flood line, which is key, which ended up addressing both the environmental crisis and the human dignity concerns that were raised. Action SA councillor Henriette Frolich notes that this success should boost the property development in areas like Erasmuskloof, Moreletta Park, Mooikloof, and surrounding areas in Pretoria in the coming months, because there are plans to develop those areas and for the city to get something back out of that. When we take a different view of this though, versus the Lonehill situation, the key differences appear to be the sustained institutional support and a clear relocation plan. The city of Tshwane didn't just seek eviction, they offered alternatives, verified citizenship status, and worked through the legal setbacks rather than just abandoning the process and saying, hey, we lost, let's move on. This stands in stark contrast to the Ginger Park situation, where eviction orders from years ago, they still gather dust. And with that dust, we have to say that property rates, they're not going up, they go down. And it's also useful to understand that this crisis extends beyond just individual property owners. As squatting rates begin to rise, the incentive to develop property and rent it out, well, that plummets, and that's not great. This creates a vicious cycle. Fewer homes are developed, which means that higher rent for remaining properties increases as supply can't keep up with demand. The very people who need affordable housing most are ultimately hurt by a system that makes property development and rental too risky for investors. One critical aspect to consider is the Prescription Act of 1969, which states that a person can acquire ownership through acquisitive prescription if they occupy land openly, continuously, and without consent for 30 uninterrupted years. While this doesn't apply to most current squatting situations, it adds another layer of complexity to long-term occupations. The numbers from recent court rulings paint a troubling picture, at least to me. In 2023, delayed evictions occurred in nearly 30% of these cases, often due to humanitarian considerations. Do you think South Africa needs emergency legal frameworks to streamline a lot of these evictions? I don't know. Maybe it does right now. Let us know down below. We're not dealing with a simple landlord versus tenant issue here. We're confronting a systematic problem where constitutional rights clash, municipalities fail to meet their obligations, and property owners bear the financial burden of a broken system. Clearly, there are proposed prevention of illegal eviction and unlawful occupation of land amendment bills that are out there in Parliament. And the aim of those is to make organized efforts to make it unlawful to occupy land, and also a legal framework that municipalities can follow to evict people much faster. But the real solutions need to be multifaceted, because we need economic liberalization to create jobs. We need rezoning of unused office blocks so that we can turn them into apartments and other livable areas. We also need to see that crushing of construction mafias, this will open up development, and also we need to protect property rights to incentivize investment and development. And it starts with sorting out the squatter issue. The Wolwespruit case shows us that its success is possible within current frameworks when there's proper planning, political commitment, and available relocation alternatives. Yet, for every Wolwespruit, there are multiple Lonehills popping up where the system remains paralyzed. The irony remains stark in all of this. In trying to protect the vulnerable, we've created a system where law breaking is inadvertently rewarded while law-abiding property ownership is punished. Until we find a way to balance these competing interests more effectively, I think that South Africa's property crisis will only deepen. Ultimately, this will harm the very people that the law seeks to protect. Thank you for watching this video right up until this point. I hope it was just as interesting for you to watch as it was for us to make for you. Maybe check out one of these other videos and hopefully they'll be just as interesting as this one. Cheers.